usage of Indian Constitution. So mind it, this one is the part from where you can address the question of what? Comparative constitutional aspect. So if I ask you Indian Constitution, can you write a question? Question: Indian Constitution is a borrowed constitution. Indian Constitution is borrowed constitution. However, this borrowed constitution represents a beautiful patchwork, or however this patchwork represents a beautiful patchwork. Critically discuss. Can you write that? Can you think over that? All right. So these are the different places from which you already understand this content, from where the different aspects has been taken up. All right. So you never suggest that Indian Constitution is a borrowed constitution. Indian Constitution does not have its own originality. It is having the originality. It is having the best things which are present in the world is present in Indian Constitution. So that's why Mr. D. Basu states this idea that Indian Constitution is a beautiful patchwork. Are you understanding my point? Then comes, I have already given you about the rule of law, implementation of rule of law, exceptions of rule of law. You know about that. Rule of law, law is supreme. We are in the place where lex rex is there, not rex lex. Popular sovereignty. But if you go to Britain, you will not have the popular sovereignty. Parliamentary sovereignty is there. India does not have parliamentary sovereignty. India does not have constitutional sovereignty. All right. India is having what? Popular sovereignty. People are sovereign. People are the king. All right. So if I talk to you, this is a very important aspect which is going to be used not just in paper number 2 but also in paper number 4. That law making philosophy. Why the law has been made? Why law will be made? The law, natural laws are eternal. All right. Natural laws are eternal, and the people will elect their representatives for making, and those representatives will make the law. This law will be what? Taking it close to the what? The law made by the representatives will be, the aim of those representatives will be to take that close to natural law. Are you understanding my point? So this is law making philosophy and the morality behind the law making. All right. Then comes fundamental rights. Now these cases were not very important for the PT, but these cases are very important for the mains. Look at it. You'll have Marbury versus Madison case. This is not the case of United States. Article number 13. For article number 13, this is the case of United States, not from India. And first time judicial review came into that. All right. Judicial review as a word is not mentioned in the constitution, but there is interpretation of article number 13, which is talking about judicial review. All right. Then comes L. Chandra Kumar case. L. Chandra Kumar case. L. Chandra Kumar case will be what? Under article number 13. Article number 13 will be for will be coming under judicial review. What is under article number 13? Definition of law. What will come under the law? All right. So even delegated legislation, bylaws, all these will be what? All these will be coming under the judicial review. Article number 226 will be for High Court. Then comes A.K. Gopalan versus State of Madras and Ramesh Thapar versus State of Madras. You know about doctrine of severability. What is doctrine of severability? All those parts which are not in accordance with the constitution, with the fundamental rights, will be nullified, not the entire fundamental rights. All right. State of Gujarat versus Ambika Mill case, doctrine of eclipse. So if the fundamental rights is nullified by the Supreme Court, the laws made for implementing those fundamental rights will be eclipsed temporarily. All right. If those fundamental rights are restored once again, so that means what? That means the law will automatically come in force. So doctrine of waiver, unlike in United States, India, doctrine of waiver does not exist. One cannot, waive off their fundamental rights. So One cannot waive off. You cannot waive off your fundamental rights by your own will. वे मीन्स छोड़ देना. तुम बोल दोगे कि मैं अपना राइट टू लाइफ जो है वो त्याग देता हूँ. कैन यू डू दैट हियर इन इंडिया? नो. Then you know about this. All these exceptions will be valid for exceptions of rule of law also. All these exceptions will be valid for exceptions of rule of law. Alright. So then article number 14, if I ask you about one word about article number 14, that will be what? This one word will be what? Equality. Alright. So this equality itself is not a static concept. This equality is a dynamic concept, and because of which you will have the what? Reservation, positive discrimination, intelligible differentia. All right, intelligible differentia. All this is related to reservation in India. All right. So M. Balsara versus the state of Bombay, you will have intelligible differentiation. What is intelligible differentiation? Intelligently differentiation should be there. That will lead to reservation. Yes. Anwar Ali Sarkar versus the state of West Bengal. There has to be rational nexus between purpose and objective in ensuring equality. So that's why again this is focusing upon reservation. E.P. Rayappa versus the state of Tamil Nadu. Equality is a dynamic concept. It is a changing concept. What do you mean by dynamic concept of equality? So equality being static means once equality is fixed, it will be fixed forever. But it is not the case. This equality is, this equilibrium of equality will be shifting towards another equilibrium. So that is what? Dynamic concept. And this dynamism can be seen through reservation in India. Now, very recently, economically weaker section has got the reservation, 10% reservation. Dynamic concept. With time, this equality is evolving. Are you understanding my point? Randhir Singh versus Union of India, this will be equal pay for equal work. Then comes article number 15. This is, here the word only is very, very important, which talks about only on the grounds of religion, race, caste, sex and place of birth. Alright, so it will be only for citizens, both against the state and private. So here, look at this. Here, this is again the idea of what? Reservation. Alright, D.P. Joshi versus the state of MP, it is talking about domicile as a valid criteria of reservation. I have already discussed all these things with you. I just wanted to show you that for mains, what you do is the, cases you must remember for mains. Are you understanding? I will give you more list of cases in subsequent classes. Alright, but first, whatever you have, you just keep it with you. Alright, do the consolidation, and after then there will be addition further, which is there. Alright, we will be adding to the content slowly but steadily 10 days before the mains examination. Alright, so Champakaran Durai Ranjan versus state of Madras, you will have reservation of SC, ST and OBC, and M.R. Balaji versus the state of Mysore. Here you will have the 50% ceiling on reservation should be there. Caste should not be a sole criteria. Backward and more backward is not a valid criteria. However, the new innovation which is coming up, this is for society also. You can write it somewhere in the box that the class within caste is being recognized. Class within caste. Example, Bihar. The concept of Dalit and Mahadalit. Concept of Dalit and Mahadalit. OBC, EBC are creamy layer, non-creamy layer. That is also what? Class within the caste. Do we have a caste within the caste? Subcaste. Yes. Subcastes are also there. Class within the caste. Class is having solely what? Economic criteria. Caste is what? Caste is fixed from the birth. It is a closed system. You cannot change it. You cannot move from one caste to another caste. Theoretically not possible. Are you understanding my point? So, T. Devadasan case, the carry forward rule is invalid. You know about carry forward rule? Okay, next time the seats which are unfilled because of the reservation will be what? Carried forward. It is invalid. All right. Then come to article number 16. It is equality of opportunity in the matters of public employment. And here you will have, there are different cases. DP Joshi versus the state of MP, NM Thomas versus the state of Kerala. Reservation in promotion is valid. Akhil Bharatiya Sochit Karamachari versus Union of India. This will be overruling Devidasan case, and they will be saying that carry forward rule is valid. Mandal Commission report, and on the basis of that, you will have Indra Sahni judgment. And on the basis of Indra Sahni judgment, recently NCBC, National Commission of Backward Caste, will be given what? Constitutional status under Article 338B. So, Indra Sahni judgment, you will have this. NCBC will be to be created. 338B. Huh? 338? MP में था 338B. So that is wrong. NCSC के लिए, हाँ. Then earlier NCSC and NCST was same, but NCST 338A and 338B is what? Before this 338B, who was to take care of OBC needs also? NCSC. Are you understanding my point? Then 77th Amendment Act 1995, in promotion of 77 promotion of SC/ST, but not for OBC. 124th Constitutional Amendment Bill, and it is now the Act also, 10% reservation of for EWS and general category candidates. Untouchability. What about untouchability? So untouchability is not defined in the Constitution, but if you see, Mysore High Court has stated about untouchability that untouchability should not strictly be seen with the words, but it should be the historical aspect which has to be included with the untouchability, which should be seen. All right. So there are these acts become very important. You will have to remember that Untouchability Offence Act, which later became Protection of what? Civil Rights Act in 1955 and Prevention of Atrocities Against SC/ST Act. All right. So do you see that Prevention of Atrocities Against SC/ST Act? Is this a bailable offence? It is a non-bailable offence. Later it is being compoundable only, but it is initially, in initial phase, it is non-compoundable. Okay. So this act is very harsh, and for that it has been criticized for its misuse. What? If you see somebody has scolded even. If some SC/ST goes to the court and he says in the court that somebody has scolded with some caste notioned words, that itself amounts to this atrocity. Not just you are going to beat them, but caste notioned words, if it is there. This one also there. So Article 18 abolition of titles. फिर भी अच्छा नहीं करके आया. अच्छा किए हो जाएगा पीटी. अच्छा चलो ठीक है, गुड. सो देखो 18 abolishment of titles, है ना. State not to confer any title except military and academic titles. So you know that, and the awards which are given to that does not constitute title. That is Balaji Raghavan versus Union of India case. Right to freedom of speech and expression, assemble, association, movement, and residence. I believe that this itself can be a question. Article 19 can be automatically suspended during which emergency? So if it is asked about proclamation of emergency, which emergency it is talking about? There are three types of emergency: national emergency, and second is what? State emergency and financial emergency. State emergency is also constitutional emergency, but it is the word proclamation is used. So that means what? 352.
Emergency due to external factors.
National emergency. My point, understand the words the proclamation of emergency is associated with national emergency. All right, 352. All right. So Article 19 will automatically be suspended, in case of external national emergency because of external regions, that is war. 359. So it will be only for citizens. Reasonable restrictions are this. You must understand this. You must remember this. Freedom of speech and expression. This is a recent case, Navtej Singh Johar versus Union of India. It is stated that IPC section 377, that is to recognize this unnatural sexual behavior, LGBT community, and this has been decriminalized. This IPC section 377. Bijoy Emmanuel versus the state of Kerala, that states that right to remain silent is also the part of what? Part of freedom of speech and expression. And Syam Narayan Chaukusi case, it can ask. I think this has been asked in UPSC. This question has been already been asked in UPSC mains. National anthem in cinema hall. Standing on the national anthem in cinema hall is voluntary. All right, voluntary. So freedom of press. Brij Bhushan versus the state of Delhi. So that states that freedom of press will be the part of freedom of speech and expression. It talks about freedom of speech of the press. And Sakal Papers versus Union of India, it has clearly mentioned that freedom of press will be the sub part of freedom of speech and expression. All right. Article 19B, assembly, you'll have this, reasonable restriction. Reasonable restriction for association will be SIPM. All India Bank employee case, right to peaceful protest, but a strike and lockout is illegal. Strike and lockout is illegal. सुन रहे हो अभी देख रहे हो अग्निपथ scheme? Is it legal? Is it legal? You have got the right to peaceful strike. Every day it is happening, but not you cannot just violate this the public property. All right, rails are being burned. लोग थे रास्ते में. So understand, this is your duty also, fundamental duty also. Which duty? Article number 51A, subclause I, to abjure violence. So just remember, this is the violation of fundamental duty also, which is happening through this Agnipath scheme. Are you understanding? So there has to be a peaceful protest. Peaceful protests are healthy for the democracy. Peaceful protests are healthy for the democracy. People have given the voice. People have been given the power. This is good for democracy. I told you that in the beginning only that it is the democracy which differentiates from Jallianwala Bagh to the protest which is happening. You understand? Today you are protesting. Today you are, and it is not just one way. I'm not saying that only the people are wrong. Government has done the right thing. If at all there are protests which are going on in your government, so government should also come forward and should address the concerns of the people. It is democracy. Government should be, for the people. People are the king. Popular sovereignty should be there. So if there are protests regarding CAA, or there are protests regarding this Agnipath scheme, or there are any other protests, government should come forward and address the concerns, address the grievances of the people. So both way it is wrong. Are you understanding my point? 19D is what? Reasonable restriction. Here, mine is the word is ST. These things you know about that. Then Article 20 is conviction of certain offences. What are those offences? Here, no ex post facto law and no double jeopardy, no self-incrimination. You understand the meaning of all this? No ex post facto law. Only in criminal cases. Example is Nirbhaya case. The one juvenile was there. but juvenile was not punished. Juvenile was not given the the punishment, because Juvenile Justice Act suggests maximum punishment for a juvenile, for a child, can be what? 3 years. That is the maximum punishment, and that is what one person has got. All right. But if you ask me about the Vodafone Cairo case, there were retrogressive taxation, which was called as tax terrorism, but it was there. It could be brought. That means what? In case of civil cases, there can be retrospective amendment, retrospective law creation. All right. But double jeopardy means no person can be punished for the same offense twice. No person can be forced to give evidence against oneself. All right. So this is procedure established by law, due process of law. I have already discussed that. This one can be separately be a question, and I think it has been asked also. How Article 21 or right to, you should understand the complete language of Article number 21. No person can be deprived of his life and liberty except by procedure established by law. So the word procedure established by law is there in Article number 21. So there are different cases. A.K. Gopalan case, only it was implemented for the executives and not for the legislature. All right. And procedure established by law was interpreted in very narrow terms. All right. But if we talk about this Menka Gandhi case, then due process of law came up, and in due process of law, judicial review scope will be widened, because it will be also be checking about what? The ethicality of the law. You know about the procedure established by law and due process of law. I have already told you. Procedure established by law, 3 checks. What? Whether the right authority is there or not, whether the correct procedure has been followed or not, whether there exists any other law with respect to Article number 21, which deprives a person of life and liberty or not. Are you understanding? And these 3 checks plus one more check, which is about the ethicality, which is about the just character of, which is about the checking the just character of the what? Procedure established by law, that is in due process of law. Are you understanding? So this is very important, these 4 cases. P. Ratinam case for decriminalizing section 306, that is what? Suicide. Gyan Kaur case criminalized once IPC section, once again IPC section 306, that is suicide. Aruna Sanwag, passive euthanasia and common cause case, living will advance medical directive. I have already explained that. है ना? पता है कि नहीं पता है? So this is very important for mains. Case Puttaswamy case, it has already been asked. Right to privacy, right to be forgotten, has been the part of fundamental rights after the interpretation of case Puttaswamy. Honorable Justice case Puttaswamy. When you write, sometimes you should be using these terms: the apex court, the honorable justice, honorable prime minister, honorable president. All right, this will give a good sense of feeling being a bureaucrat, being a part of system. If you write honorable justice case Puttaswamy case, what is wrong in that? Honorable apex court, ये सब एक के ऊपर एक केस के ऊपर दूसरा केस है. So what is the case in case of euthanasia which is valid now? Common cause case about the living will, about the advance medical directive by a group of board members consisting of doctors and family members. There will be the advance directive which will be provided by the person in his senses, and according to that only the decision has to be taken about the euthanasia. Suicide is recently decriminalized because it is about the mental state that will come in society. Okay, this is golden triangle test. So I told you for judicial review, Article 14, 19, 21. This is very important. You make this diagram. You make this diagram for this right to privacy under Article number 21. This golden triangle test. IPC section 497, that is adultery. So in adultery, Yusuf Abdul Aziz versus State of Bombay and Saumitri Vishnu versus Union of India case, IPC section 497 was upheld. Why? Because woman was considered as the property of man. and this was a patriarchal notion even in the what? Even in the law. Woman was considered as the property of man. So it was upheld. But Joseph Stein versus Union of India case, IPC section 497 was scrapped, because it could not pass the golden triangle test. What was the golden triangle test? 14, 15 and 21. Here, these are two different triangles. Here 14, 15 and 21. Alright. So this is judicial review only. This is judicial review only. That in this case, IPC section 497 could not stand up. But adultery is now no more a criminal offense, but it could be a valid ground for divorce, civil purposes. All right. Article 21A, I have told you, 6 to 14 years, rights of the children, continuous and comprehensive, no corporal punishment, teacher pupil ratio, 25% reservation, age appropriate classes, especially trained teachers for differently able child. All right. So then article number 22. So you will have some organized crime related act. Again, this will be used in internal security. What do you understand by this organized crime? What do you understand by organized crime? Not just drugs. When three or more than three people, come together for a common purpose to conduct a crime, to commit a crime. So that will be what? Organized crime. So Gukoka, Makoka, Maharashtra, Gujarat Control of Organized Crime Act, Maharashtra Control of Organized Crime Act. This will be allowing for preventive detention, and mind it, preventive detention is what? A black spot in Indian democracy. It is not present in any other democracy. So you understand all these things? We have already discussed that. So now you know about this recent amendment in Child Labor Prohibition and Regulation Act 1986. This will again be used in what? Society also. So you should just read that children below 14 years will be what? Complete ban on employment in hazardous industries. The list of hazardous industries has been reduced from 83 to 3, and outside school hours for the purpose of skill development, for the purpose of entertainment industry only. All right. It is allowed to work in the this. Okay, this amendment has synchronized this with RTE Act. Complete ban of children in hazardous industry. Hazardous industry. Family business for the purpose of skill development and outside school hours. It should not be during the school hours. वही है चाइल्ड लेबर वाला ही. So child labor prohibition and regulation act, that is the same. हाँ वो सेम ही है. This is the child labor prohibition and regulation act. उसी में अमेंडमेंट हुआ है. The amendment has been done in that only. ठीक है. Then from 25. So if you are asked about the question on secularism, so how many times secular word has been used? Two times in preamble and in article number 25. So for secular notion, you will be talking about starting with preamble, then article number 25, 26, and then article number 25, 26 in the fundamental rights, 27 also for religious denomination. SR Bommai judgment you will be talking about. Secularism is the basic structure of our democracy. So on secularism, you write about that. What are the constitutional aspect of secularism? This is very, very important. All right. Starting from preamble, then fundamental rights, 25, 26, 27, 28. No religious instruction should be there in the government aided, and cultural and educational rights also regarding the minorities, because here our constitution recognizes which kind of minority. What is the definition of minority? According to United Nations definition of minority is strictly on the basis of numbers. Strictly on the basis of number, our constitution recognizes religious and linguistic both minorities. All right. So article number 30 is what? Again, right to property for minority and institutional institutions. All right. So this one is there, 31A, 31B, 31C. No mains question directly which comes. Here comes the mains question. Anna, write the question. Write the question. Right to constitutional remedy. Right to constitutional remedy is the soul of our governance system. Soul of our governance system. B.R. Ambedkar. It is given by what? B.R. Ambedkar. Very soul of constitution and heart of it. Look at this. It is written also. This question directly can be asked. Here you can write examine, critically examine. In just very brief, I am going to give you the idea about how to write different words today only. Okay. So when you have to write about article number 32, then you will have to talk about writ jurisdiction also. And if they are specifically asking about the writ jurisdiction, this chart is a wonderful chart you can create. All right. Then martial law and national emergency, what is the difference? All right. Then national emergency, you know about that. DPS.